Welcome, everyone, to the Network for Public Health Law webinar, Beyond Borders, Global Legal Innovations for Countering Parental Rights and Prenatal Personhood in the U.S. Abortion Context. I'm Kayleen Klarich, Associate Director of Communications at the network. A couple of housekeeping items before we get started. You will receive an email notifying you when the slides and recording of today's webinar have been posted to our website. Feel free to use the Q&A function throughout the webinar if you have questions, and we'll try to get to as many of your questions as possible. With that, I'd like to introduce today's moderator, Kathy Hoke. Kathy is Director of the network's Eastern Region and Professor and Director of the Legal Resource Center for Public Health Policy at the University of Maryland Curie School of Law. Kathy, I'll hand it over to you.
Thank you, Kayleen. Next slide. Welcome, everyone, to the network's webinar. Just very briefly, many of you probably already know about the network, but let me tell you a little bit about us because I have to take that opportunity to market ourselves. But the network is primarily funded by the Robert Wood Johnson Foundation, but we also do grant work and receive funds from other philanthropic organizations for which we are incredibly grateful. And that allows us to provide free technical legal assistance to state and local public health officials, legislators, advocacy organizations, community members, folks who are attorneys for any of those entities or organizations. So we can provide that legal technical assistance, short of advice, but helping you work through a particular legal hurdle or opportunity that is presented. We also proactively address legal issues in myriad public health issues. So you can go to our website and see the full array of issues that we work on, and we produce fact sheets, policy briefs, 50-state surveys and the like to really create a knowledge base for folks in particular areas. One area of focus for us, of course, is maternal health and reproductive health care access, which undergirds the webinar that we're doing today. So I encourage you, if you have not, spend a little time on the network's website to see what resources we might have that would support you. And you can always hit the Ask a Question button to connect by email with the network to ask any particular questions that you might have. Next slide. I am very excited to introduce the speakers who you're going to hear from today, and I want to in advance express my gratitude to each of them for joining us. And you're going to hear about issues associated with youth access to reproductive health care, as well as fetal personhood throughout the course of today. You're going to hear first from Jennifer Driver, who is the Senior Director of Reproductive Rights at the State Innovation Exchange, an incredible organization that likewise is producing affirmative work that can be very helpful. So I encourage you to look more into the exchange as well. Donna Repka, who's a research associate at the University of Toronto. Thank you to our Canadian friends in so many ways now, who's on the Faculty of Law there. Wendy Hyped, who's a Senior Reproductive Justice Counsel at Legal Voice, who's doing incredible litigation and policy work in the reproductive healthcare space. And my friend Rebecca Reingold from the O'Neill Institute at Georgetown, where she serves as the Associate Director. You can click onto bios and hear more about these incredible women. Next slide. But it is, really my pleasure to kick it off with Jennifer. I just want to remind folks, like Kayleen said, please use the Q&A box. If you have any questions, I'll be looking at that throughout the discussions, and we'll get to as many of your questions as possible. And the slides will be made available to you, and a recording of the webinar will also be made available on our website shortly after today. So take it away, Jennifer.
Thank you. Thank you so much. And thank you for having me. As mentioned, I'm Jennifer Driver. I'm the Senior Director of Reproductive Rights with the State Innovation Exchange, and we are a national organization that works with state legislators in every state, U.S. territory, who are advancing reproductive rights across the country. I will get us started talking about young people and their access in the U.S. Next slide, please. Before we jump in, I wanted to just give a little bit of an overview of some reports that we released in partnership with the O'Neill Institute and Legal Voice. It's the Global Legal Comparison Reports. And this resource is a 5-part comparative report series that really examines how abortion is regulated globally and what it means for the United States. Each report, its focus is on a major structural battleground in abortion law, so countering prenatal personhood, removing criminal law from abortion regulation, limiting parental involvement, mandates for young people, regulating religious refusals, and treating abortion as healthcare rather than a moral or criminal exception. Across all 5 topics, the report synthesizes international human rights standards, global public health guidance, the jurisprudence and legislation of selected countries. They then situate the United States within the borders of the global context and reflect on implications for state-level policymaking. The unifying theme is abortion exceptionalism. We know abortion is healthcare, yet it's regulated unlike any other essential medical care service. While exceptionalism exists in many countries, the US represents an extreme example of both before Dobbs and after Dobbs. And so the purpose of this series is not to be exhaustive, it's to expand our legal imagination and highlight concrete policy models and arguments from around the world that demonstrate that abortion care can be regulated in ways that respect autonomy, dignity, and public health. And so at a time when state legislators are the primary arena for reproductive rights in the US, this comparative law really becomes this practical tool for innovation, resistance, and reform. And we've heard directly from state legislators how they're using this to really change and expand their thought around the policies and the legislation that they're putting forth. Next slide, please. So we thought it would be helpful for us just to ground ourselves in the landscape of youth access in the US. When we talk about healthcare, what we're really talking about is power, the power to determine who gets to decide, who is trusted to know what's best for their own body, who gets to keep their medical information private. And for young people in the United States, that power is systematically stripped away. The barriers for young people in the United States are compounded by a myriad of issues. We already know that adults face these barriers when seeking care for abortion, and that doesn't go away if you're a young person. It is actually magnified. Young people often have no independent income, so travel becomes an enormous obstacle. Gas, flights, hotels, food, and sometimes childcare or for siblings, it can all add up really quickly. They may also miss school or work, risking academic consequences or lost wages. If they cannot safely use their parents' insurance, they may have to pay out of pocket for abortion care. There are also some photo ID requirements and concerns about immigration status that create additional barriers and fear. All that layered with delays or intimidation, including mandatory waiting periods and parental involvement laws in many states. But the challenges really don't stop there for young people. Many young people who are seeking abortion are navigating this complex and could be unsafe family environment. Some are experiencing emotional abuse, some physical abuse, maybe family violence. And then there are those immigration, detention, and foster care, or those involved in the child protective services. And so there are many advocates that call kind of these de facto orphans, where there are parents who are either deceased, missing, detained, deported, or incarcerated. In these circumstances, requiring parental consent is not protective. It can also be dangerous. In the United States, what we're witnessing is this deliberate rollback of young people's autonomy in healthcare, particularly in sexual and reproductive health. And when we look globally, this regression becomes even more clear. So this Beyond Borders reports that we have provides this powerful comparative lens, and it shows that many countries that have moved towards expanding confidential access and recognizing young people rights as these rights holders. By contrast, in the US, it's increasingly out of step with the global public health standards and human rights norms. What I would often see when I worked directly with young people and on behalf of a lot of the policies for young people was young people were often the carve out to a lot of the legislations. We would say, okay, we're going to push this bill. But if there was a young person brought up, they would carve out to mean that it was only for adults who were seeking access to care. Next slide, please. So we know that young people remain the primary targets of the anti-abortion extremists. It's not accidental, it's really strategic. Young people are often framed as vulnerable or naive or incapable of making decisions. And that framing is really then weaponized to justify surveillance, control, and forced parental involvement. And so this rhetoric often sounds protective, but it's really the policies that are very punitive in practice. And we see this in parental consent and notification laws that are defined as these family values measure, even when they endanger young people experiencing abuse or instability at home. So what then happens, we see this with crisis pregnancy centers targeting young people with misinformation, restrictions on sex education. We see it with book bans and these attempts to criminalize providers who often provide confidential reproductive health care for young people. And I want to be very clear. Abortion is not the endpoint here. It is a matter of time before anti-abortion extremists really move aggressively against young people's access to contraception. The groundwork has been laid for years. We already see these legal challenges to authority of minors to consent to care, questioning the legitimacy of hormonal contraception. And so the playbook is very familiar. They've already made it illegal in many states for transgender young people to access gender-affirming hormonal therapy under the guise of uncertainty. The same argument is we don't know what is best, what it does to young people's bodies, or we don't know the long-term impact. It's the same argument that will be used against hormonal birth control. It'll raise doubt, invoke protection, manufacture uncertainty, and restrict access. And so the pattern is consistent. First, question the capacity, then question the safety, then criminalize the care. And we see that with young people on a myriad of sexual and reproductive health services, including abortion. And what happens to young people today rarely stays confined to young people. Policies that are tested on young people first because they are young people and they have less political power and fewer resources to challenge in them. But once restrictions are normalized for young people, the logic then expands. And what happens to young people today becomes a template for the rest of us tomorrow. So it's really important that we are paying attention to the restrictions related to young people. So when we defend young people's access to abortion, we're not only protecting and providing young people the essential care that they need, we're protecting the broader principle of abortion. Or individuals, not the state. The individuals themselves, not the state, should control their bodies and the medical decisions. And so young people are often on the front lines of these attacks, but they're really early warning signs for the rest of us in this country. And so if we pay attention to what's happening to them, we can clearly see where the broader reproductive rights landscape is heading. Next slide, please. And so what we know is that policy change is absolutely possible at the state level. Even states or even restricted federal environments, states retain this enormous power over how young people can access care. And so we can see where states can repeal and reform parental involvement requirements. Parental consent and notification laws are not inevitable. They are policy choices, and they can be undone. And some states have already started moving towards protecting minors' confidential access to abortion care, recognizing that forced disclosure can put young people at risk. We also can see where states can codify strong confidentiality protections. States can rethink the rigid cutoff age. In many countries, access is not determined by this arbitrary birthday. Instead, clinicians access a young person's decision-making capacity. And states in the US can actually do that as well. So these are not radical ideas. They're not fringe proposal. Globally, individualized capacity assessments, confidential access, and recognition of young people's rights as holders are standard practice. Many systems operate on understanding that young people are developing autonomy and deserve dignity and care. And so the real question is not whether these policies are possible, it's whether we are willing to treat young people as people capable of making decisions about their own bodies and deserving privacy, safety, and trust. Thank you. I'm going to pass it to Dana, I believe.
Thank you, Jennifer, and thank you so much to the Network for Public Health Law for convening this timely conversation. It's truly an honor for me to be here alongside Jennifer, Wendy, and Rebecca, and I'm especially grateful for the opportunity to contribute a perspective from Latin America at a moment when legal strategies grounded in parental rights are reshaping abortion debates across the world and especially in the US. My name is Dana. I am an Argentine lawyer specializing in sexual and reproductive health law. I hold an LLM from the University of Toronto, where I currently work as a research associate at the International Reproductive and Sexual Health Law Program. My presentation today is titled Young People Abortion Decision Making in Latin America, and what I want to do is to situate our regional experience within this broader transnational movement. In the US, as Jennifer explained, we are witnessing efforts to curtail young people's autonomy through expanded parental control. And actually, in Latin America, we have long wrestled with similar tensions, particularly around the idea that adolescents are incapable of making reproductive decisions on their own. Next slide, please. So what I will do three things. First, I will describe the predominant regulatory model across Latin America on young people abortion decision making, which much like many U.S. states remains anchored in a protective paternalistic framework grounded in mandatory parental consent. Second, I will introduce an alternative model that has emerged in Argentina, rooted in the doctrine of evolving capacities. And third, drawing on Argentina's model, I will reflect on which kind of narratives enable a move from paternalism towards autonomy, and what lessons I believe may be useful in today's US context. Next slide, please. So as I said, much like the majority of US states, Latin America largely remained anchored in what I called a paternalistic protective model that imposes mandatory parental consent requirements for adolescents seeking abortion care. As part of my LLM thesis, I reviewed abortion laws, health regulations, and child rights legislations across Latin American countries that have at least some legal ground for abortion, with the goal of identifying their specific consent requirements for adolescents. What I found is that 10 countries in the region have explicit regulations on adolescents' informed consent for abortion services, and 7 of them impose mandatory parental consent. These laws function as a major yet often overlooked barrier to care as they erode adolescents' autonomy in practice and they delay access to essential reproductive healthcare services. As I mentioned, I call this model a paternalistic protective model. It is paternalistic because it assumes adults, especially parents or guardians, always know what is best for adolescents and should therefore make decisions on their behalf. And it is protective in that it portrays adolescents as inherently vulnerable, needing protection rather than acknowledging them as right holders with evolving capacities. Next slide, please. Something worth mentioning is that within this dominant model in Latin America, I identified 2 main variants. First, some countries require parental consent for all minors under 18 who are looking to have an abortion. This is the case in Costa Rica, Guatemala, Paraguay, and Uruguay. This approach does not therefore differentiate by age, maturity, or type of abortion procedure, which means it completely eliminates the principle of progressive autonomy by treating all adolescents the same. Next slide. Thank you. A second group of countries does introduce age-based distinctions, but adolescents still never reach full decisional autonomy. For example, in Brazil, those under 16 do need full parental consent, but those between 16 and 18 need joint consent. And in case of disagreement between the adolescent and the adult about having abortion, the adolescent's decision prevails. Panama follows this exact same model, while Chile has a slightly more flexible one. Adolescents under 14 must be accompanied by a guardian, with those 14 and older only have to inform them. But despite these nuances, the logic remains, right? Adults control the decision. Next slide, please. Now, And this is what I wanted to emphasize. There are two key empirical problems with this model, this paternalistic protective model that imposes mandatory parental consent. First, it lacks empirical support. Research in adolescence psychology and medicine shows that 16 and 17 years old have decision-making capacities comparable to adults, especially regarding pregnancy and abortion. For younger adolescents, capacity depends more on social context, access to information, and the quality of communication with healthcare providers than on age alone. So it is not true that adolescents are not capable enough to decide whether to have an abortion. Next slide, please. Second, this model is far from harmless. According to the World Health Organization abortion care guidelines, third-part authorizations, such as parental consent requirements, systematically lead to delayed access, continuation of unwanted pregnancy, increased risk of family conflict or violence, and a higher likelihood of unsafe abortion. Next slide, please. Furthermore, I have identified two recurring features of the paternalistic protective model in Latin America that are particularly misaligned with adolescents' realities. One is that all these countries that impose mandatory parental consent also have rigid companion rules, meaning adolescents can only be accompanied by parents or legal guardians. This contradicts all the empirical evidence that shows that adolescents often rely on other trusted adults, such as siblings, teachers, social workers, especially when facing violence at home. Secondly, the majority of countries that adopt the paternalistic protective model use judicialization as an alternative mechanism when parental consent cannot be obtained. Indeed, much like the judicial bypass process in the United States, several Latin American countries require adolescents to seek court approval when parental consent is not available. However, the evidence shows that this is extremely ineffective. It adds delay, stigma, and emotional burden, while also functioning as a resource that only adolescents with greater financial and social resources are realistically able to access. Next slide, please. But now, not everything is lost. There are alternative models in the region that place adolescents' reproductive autonomy at the center of the regulation, and one of the clearest examples is the Argentine model, which regulates adolescents' decision-making through differentiated age groups aligned with the doctrine of evolving capacities. To put it simply, for those who are not familiar with this doctrine, the doctrine of evolving capacities is a doctrine that arises from Article 5 of the CRC, the Convention on the Rights of the Child. In the literature, especially in Latin America, it is also known as the principle of progressive autonomy, and it basically holds that adolescents have greater rights as they mature. So based on this doctrine, here's how the Argentine model works. Adolescents aged 16 to 18 have full decisional capacity for all aspects of reproductive healthcare, including abortion. This means that they can consent to have an abortion without any kind of adult involvement. Those aged 13 to 16 can also consent independently, with the only exception being if the procedure involves a serious risk, which abortion rarely does. So in the vast majority of cases, they will also be able to consent to have an abortion on their own. And finally, girls under 13 do have to be accompanied by an adult, but importantly, this can be any trusted adult chosen by the child, not only their parents. And if no one is available, a health professional is authorized to act in that supportive role. Next slide, please. So what makes this model distinct? First, it affirms progressive autonomy, the idea that capacity grows as adolescents mature, rather than remaining static as assumed in the protective paternalistic model. Second, it incorporates the idea of relational autonomy, which is a concept that came from feminist legal theory, and in this context helps us to recognize that adolescents, especially younger adolescents, do not make decisions alone, but rather make decisions within a network of trust. family members, teachers, social workers, and healthcare providers, and that all of them can support the adolescents, but not make decisions for them. So in that sense, I think that this model does not romanticize independence or reinforce paternalism. Instead, it creates conditions for adolescents to make informed, supported, and confident decisions. Next slide, please. So what can we learn then? For me, there are three key lessons that stand out. First, eliminating parental consent requirements in Argentina improved public health outcomes. After the adoption of this model, and especially combined with improved access to contraception, adolescents' fertility rates fell sharply. 33% among 15 to 19 years old and 27% among 10 to 14 years old. Two, this model shows to be operationally feasible. Clear age-based rules in the National Abortion Protocol give providers, healthcare providers, certainty in how to deal with adolescents seeking abortion, while simultaneously not giving space to arbitrariness. And finally, this model offers concrete alternative to judicial bypasses for cases involving disagreements with parents or guardians, particularly for girls under 13. In those cases, as I explained, the law provides for first, trusted non-parents adults, and second, the health team itself as sources of accompaniment. So in sum, I think that this model shows that the rights-based model is normatively principled, clinically workable, and socially protective. Next slide, please. So what I wanted to conclude with is not merely discussion of Argentinians' response to opposition, because we did have opposition, but rather showing you four broader narrative frameworks that are derived from the Argentine experience that suggest a path to move past protective paternalism, but advocating for the elimination of parental consent requirements and the full recognition of adolescents' legal capacity. The first affirmative narrative that I will say helps justify the shift towards progressive autonomy was reframing what protection means. Protective paternalistic model that justify the imposition of parental consent requirements assume that parental control equals safety. However, the evidence shows that mandatory parental involvement can actually expose adolescents to violence, coercion, expulsion from the home, or forced continuation of pregnancy. Reframing protection means recognizing that in many cases, safeguarding adolescents requires respecting their adolescents' autonomy, not overriding it. Second, grounding autonomy in science, not ideology. Adolescents' capacity for medical decision-making is not only a political claim, it is empirical supported by evidence. As I mentioned earlier in my presentation, developmental psychology and medical ethics research consistently shows that adolescents, particularly those older than 16, demonstrate cognitive capacities comparable to adults in healthcare decisions. And even for younger adolescents, capacity depends more on context, information, and support than on chronological age alone. So anchoring reform in evidence disrupts narratives of immaturity. Third, advancing relational autonomy. Opponents often argue that removing parental consent leaves minors alone. The Argentine model demonstrates the opposite. Autonomy can be structured as a supported decision-making where adolescents are accompanied by trusted adults of their choosing or by healthcare teams when necessary. This reframes autonomy as embedded, as relational, rather than isolated. And finally, centering lived experience and real-world harm. Legal debates about parental rights often operate at a very abstract level. But the lived consequences of mandatory consent, delayed care, unsafe abortion, judicialization, and stigma are concrete and documented. Elevating adolescent stories shifts the frame from theoretical parental authority to tangible health outcomes, and rights violations. So taking together these four narratives, reframing the debate, use evidence, stress support decision-making, and lived harm, provide a coherent foundation for abandoning paternalist models and embracing evolving capacities, embracing protective, progressive autonomy. And perhaps most importantly, what Argentina's experience underscore is that parental consent requirements are not a neutral safeguard. They are a legal barrier that relocates decisional authority away from the person who is pregnant and toward third parties. And if the goal is to protect young people, the most effective approach is not actually to control their decisions, but rather to keep them with accurate information, confidential and timely care, and supportive structures that respect their evolving capacities. This is the shift I hope we can take from this regional experience towards framework that recognize adolescents as right holders and towards policies that recognize that expanding young people's reproductive decision-making is operationally feasible and evidence-based. Next slide, please. Thank you so much. I really hope this Latin America perspective is helpful as we think about how parental rights, about how mandatory parental consent requirements, narratives travel. And I'm really looking forward to the discussion and the Q&A. Thank you.
Hi, everyone. Thank you for having me today. And I'm going to speak today on the gaining momentum of legal fetal personhood in the United States. And I look forward to hearing all of your questions in the Q&A. And I'm going to jump right in because of time constraints. And I'm going to start by acknowledging that the very earliest human recordings show that people have long regarded a fetus as having profound value, not just for the pregnant person, but for the community and for the family. And not just in a personal sense, but in a religious sense, in a moral sense. All of these things remain true. But I'm not here today to talk about if a fetus is valued in the United States. I'm here to talk about the legal rights of a fetus, specifically the idea that a fetus is a legal entity separate from the pregnant person. That theory is legal fetal personhood. Now, the idea of legal fetal personhood is not new, but it's been gaining momentum since the Dobbs case in the United States. And I'm going to spend a minute or two with you today outlining what legal fetal personhood is, the danger it presents, and how it was present in this country before the Dobbs case, before I outline what's happened since that case and how the United States is going in a different direction than most of the rest of the world. Legal fetal personhood is the idea that every single stage of fetal life, including the collection of cells formed at conception, is entitled to all of the same legal rights as already born people. This is an extreme concept. It gives a fetus, an embryo, a blastocyte, or a zygote, all the rights of a born and living person. And it confers those rights whether those cells are residing inside the uterus of a pregnant person or in a test tube. Under a legal fetal personhood regime, all of these cell collections must be treated as if they were a living child. And as you can imagine, that is legally unworkable. Can we go to the next slide, please? Okay, thank you. But the concept of legal fetal personhood goes even further than that, because when the law recognizes a single rights-bearing person in a pregnancy, traditionally the pregnant person, then that is the person who holds all of the decision-making power for all of their medical needs and all of their lifestyle choices. We individually or as a community may not agree with every single choice, but overall, those are their decisions to make. Bestowing full legal rights on a fetus means that there are now two equal human beings in one body during a traditional pregnancy. And the pregnant person cannot be trusted to make the decisions for that second person, the fetus. So legal fetal personhood goes further. It takes the decision-making power out of the hands of the pregnant person and gives it to the state. And as I'll explain, this is already having dire consequences for pregnant people. But before I turn to that, I just want to quickly sketch out for you how the idea that the fetus is a separate legal person has evolved in the United States. Next slide, please. In the first US case on the topic, the Supreme Court of Massachusetts held that injury to a fetus was only recoverable to the pregnant person, not to the fetus as a separate legal entity. In other words, a pregnant person who suffered a recoverable injury at the hands of someone else could recover and might even be able to recover more or differently because of their pregnancy, but the fetus itself was not a separate entity entitled to their own recovery. That case was in 1884. And the next case to consider the same issue 6 years later agreed. And that's when an Illinois court also said that an infant could not recover for pre-birth injuries because a fetus is part of the mother, part of the pregnant person, and not a legal person on its own. And over the next several decades, a number of courts across the United States agreed: New Hampshire, Louisiana, New York. In fact, the idea of legal fetal personhood, while absolutely existing, did not begin to gain footing in the United States until 1973 with the Roe versus Wade decision. Less than 1 week after that decision was published, the first of what would be almost 300 federal proposals to establish a fetus as a separate legal entity was introduced in the United States Congress. And most of them did not go far, but they persisted. They often had dozens of sign-ons, and they helped to normalize a conversation. That conversation is, if you believe in the value of a fetus, then you must necessarily believe in the separate legal personhood of that fetus, even though values and legal rights are very different. And in the 2000s, this belief that values and legal rights should be together became part of the judicial nomination and confirmation process, figured more prominently in the movement to ban or restrict abortion healthcare, and began making its way into the margins of state laws across the country. This mostly happened in the areas of criminal and family law, and most often states sought to interject their authority between the pregnant person and the fetus in situations where substance abuse was present or even suspected. And I can direct you all to a number of articles showing how legal fetal personhood creep was occurring in the United States and at the federal level in the years after Roe versus Wade. But for now, overall, because of time constraints, allow me to represent to you that in the years between Roe and Dobbs, legal fetal personhood found traction. But it's since Dobbs, in these last couple of years, that the scheme has gone further. Let me give you a few examples that I believe show how the United States, in contradiction with much of the rest of the world, has embraced legal fetal personhood to the detriment of both the pregnant person and the rule of law. May I have the next slide, please? Okay, one of the more obvious areas in the United States where this has happened is in assisted reproductive technology, or ART, most specifically in IVF, in vitro fertilization. Now, as I've said to you today, under a legal fetal personhood regime, there is effectually an actual legal human being with the full rights of any other human being as soon as fertilization takes place. But even for folks who subscribe to that, few of them assume that would hold as true in a test tube as it does in utero. That understanding changed in 2024 when an Alabama court held that frozen test tube embryos could be considered full rights-bearing children in the eyes of the law. Let me tell you what happened. After successfully undergoing IVF treatments, 3 couples had remaining embryos stored at an Alabama medical center. An intruder broke in, dropped, and destroyed those embryos. And the 3 couples then sued under Alabama's Wrongful Death of a Minor Act, and they alleged that the frozen test tube embryos were their minor children. That claim was upheld by the state Supreme Court, and they found that legal fetal personhood required recognizing that frozen embryos at any stage of development are, and I quote, extrauterine children and must be treated as actual living children for the purposes of that statute. Now, that decision, while shocking, didn't come out of nowhere because they never do. It was the culmination of a multi-years effort to establish legal fetal personhood in this country. Legally, in Alabama, that began 6 years earlier in March of 2018. 2018 was the year that Alabama voters passed a constitutional amendment to, quote, support the rights of unborn children. And once the Dobbs decision came out in 2022, that amendment added a specific article to the Alabama state constitution, which declared the state's interest in protecting the rights of unborn children in all manners and in all measures. That was in 2018. And I should note for you that 2018 was also the year that Mississippi passed its 15-week abortion ban that would end up being the Dobbs case. So a watershed year whose impact is certainly more fully felt down the road. Now, despite the outcry after this extrauterine children decision, neither the state of Alabama nor federal lawmakers have been able to pass laws that fully protect IVF. And Alabama is not the first state to have assigned some form of personhood to test tubes. And since the decision, a number of additional states have introduced laws that would find embryos at all stages, in or out of the human body, to be full legal rights holders. This could be devastating for in vitro fertilization, but it's not the only area threatened as legal fetal personhood progresses in the United States. Can we have the next slide, please? Thank you. Another area where post-Dobbs, legal fetal personhood has made incursions into the United States, where it has been rejected elsewhere, is in contraception. Because under a legal fetal personhood scheme, the creation of a human being with full legal rights begins at conception, not at implantation, but at conception. And under this definition, any action that disrupts a pregnancy or prevents implantation causes the killing of a human being possessing full legal rights. This has significant consequences, not only for abortion, but for contraception, particularly, although not only, for IUDs and EC, which is emergency contraception. So just to go back to my Alabama example, after issuance of the IVF decision that I just told you about, there was a fear that took hold that that decision could be used to prohibit contraceptive access in the state. And in fact, it prompted lawmakers in that state to introduce a bill specifically targeted to protect contraceptive access. And that same uncertainty prompted similar bills in other states, some of which became law and some of which we did not. Some states also introduced constitutional amendments to attempt to protect the right to contraception, which now more and more people are recognizing is in danger from illegal fetal personhood proponents. And in other words, where this leaves us is that the United States now has a patchwork of protection, and your access to IVF and contraception might depend on your zip code. And even within a zip code, there's a lot of confusion in the United States right now. And I'll use one example from the states, Missouri. Since the Dobbs decision, Missouri has gone back and forth between a near total abortion ban and pre-viability abortion access. It's confusing. But during the period of the ban, the reach of that ban was unclear, not just to the citizenry, but to the state's leadership as well, because the ban did not define pregnancy, but did establish legal personhood for fertilized eggs. And after the ban went into effect, the governor of the state said publicly that the state's health department was evaluating and would clarify whether the ban would affect access to contraception in the state. That uncertainty led St. Luke's, which is one of the state's major hospital systems, to stop providing Plan B because they felt that emergency contraception might be mistaken for a banned abortion service under legal fetal personhood. This was later resolved, but it shows that while the legal limits are evolving and being tested across the United States, the public understanding of what is and what is not allowed also plays an impact into how people access the services they need. May I have the next slide, please? Thank you. Okay, time constraints do not permit me to delve more deeply into the two areas I've already highlighted for you, or to go into the other areas where the ascendancy of legal fetal personhood in the United States has had an impact. But I want to at least note them for you, and I'm happy to send follow-up materials or answer any questions about this. But these examples include medical decision-making, which is the right of not only pregnant people, but people of reproductive age to make decisions about the drugs that they take, the medical procedures they undergo, and the medical procedures they are permitted to refuse. Stem cell research, subnational constitutional rights, generally at the state level, criminal law, family law, and of course, abortion healthcare. May I have the next slide, please? Thank you. Okay, I just want to stress that in the United States, fetal personhood incursions are already accelerating in 2026, and we are not even fully 2 months into the year. And that's happening at all levels. So federally, I'm going to highlight two federal proposals. The first, in the Senate, there's a major personhood at fertilization proposal, which is explicitly framed for 2026 and seeks 14th Amendment equal protection for both born and preborn human persons. In the House, which has gotten a little bit more notice, there's a bill introduced that declares that the right to life guaranteed by the United States Constitution is vested in each human being at all stages of life, including the moment of fertilization or cloning. Outside of the federal government, there's also been a lot of activity. Puerto Rico enacted a personhood law that recognizes an unborn child as a natural person at any stage of gestation. Florida is looking at a bill that would allow wrongful death actions on behalf of fetuses. New Hampshire's looking at a bill that includes establishing that personhood is recognized at the end of 20 weeks of gestation. Wisconsin has an interesting bill relating to unborn children that would take away the definition of abortion from certain medical procedures. And at first that sounded fine to some advocates, because the word abortion has become so stigmatized, but it's really not fine, because the bill changes the terminology of some, but not all, life-saving procedures, so that only some are no longer called abortions. And that's typical because medicine is rarely fully captured in legislator lists. And it's also a signal that abortion healthcare is next on the chopping block, because once you can say that abortion is no longer needed because some life-saving procedures are no longer called abortions, why do we need abortion? So that's troubling. Arizona has a few personhood bills coming up, including one that would backdate child support payments to the date of a positive pregnancy test so that preborn children are included in child support payments. There's also ballot initiatives across the country. Nebraska has one that would define a person as a preborn child beginning at fertilization, and then use that definition in every aspect of Nebraska law. So overall, we can see that legal fetal personhood proponents are continuing to assert their belief that legal fetal personhood is equal to, or I would say even more value than, in many instances, the personhood of the pregnant person. I see I'm a little bit past my time, so thank you. I look forward to delving deeper into any aspect of this, and I will pass it on to my colleague, Rebecca, who will talk about how the United States experience is very different from that of the rest of the world. Thank you.
Thanks so much, Wendy. And thank you, Kathy, and to the Network for Public Health Law for this opportunity to share some of our forthcoming international comparative research on prenatal personhood. And just a quick note that when I use the term prenatal personhood, I'm speaking to the exact same concept Wendy explained so well during her presentation and referred to as legal fetal personhood. So as Jennifer mentioned, this research is part of a larger transnational project that seeks to bring abortion law and policy experiences from around the world to the US. And one of the project's main objectives is to situate the United States in the broader global context. And what our research has shown is that the United States is often an outlier when it comes to abortion law and policy. And of all the topics we looked at, this trend is arguably most striking in the context of prenatal personhood. So for context, efforts to advance prenatal personhood are not unique to the United States. Over the past several decades, numerous jurisdictions have grappled with the prenatal personhood movement's push to establish and expand the legal rights of embryos and fetuses. What our comparative research showed us was that in other countries, just like the United States, prenatal personhood can advance or emerge through a range of legal pathways, whether it's through an amendment to the Constitution, a legislative reform process, or one or more judicial decisions. And just like the United States, other countries have seen prenatal personhood threaten the legality of various reproductive health services, whether it is abortion, assisted reproductive technologies, or even contraception. However, what sets the US apart from the rest of the world is that the overwhelming majority of other countries have tackled prenatal personhood, have rejected the idea that embryos and fetuses have fundamental rights. So today I thought I would share a couple of concrete examples of other countries' decision makers grappling with prenatal personhood and share a few reflections on key takeaways for the US context. So next slide, please. So I'll start with assisted reproductive technologies. Globally, Costa Rica is one of the only countries, if not the only country, to have banned in vitro fertilization outright. The country did so in 1995 when the Supreme Court's Constitutional Chamber ruled that the destruction of embryos created as part of the IVF process violated the Costa Rican Constitution's right to life. Notably, the Constitutional Chamber cited international human rights law, referencing the American Convention on Human Rights' Right to Life from Conception provision and other international human rights treaties' non-discrimination provisions. 9 infertile couples in Costa Rica then filed a complaint against the Costa Rican government in the Inter-American Human Rights System, alleging that the ban violated their rights to private life, to form a family, and to non-discrimination. The Inter-American Court of Human Rights decision in this case, Artavia Murillo versus Costa Rica, has come to be known as the landmark IVF case in the international human rights law context. In its decision, the court stressed that the question of when life begins can be evaluated from biological, medical, ethical, moral, philosophical, and religious perspectives. Accordingly, it is not a court's role to determine which theory should prevail and to thereby impose one set of beliefs on an entire society. The court also examined other human rights instruments, jurisprudence from other countries, and global regulatory trends related to IVF, which largely permitted it in most jurisdictions. It also held that Costa Rica's IVF ban failed to consider or balance conflicting rights and led to an arbitrary and excessive interference in prospective parents' rights to privacy, family life, among other human rights. So what the court ultimately held was that the American Convention's right to life provision did not grant embryos and fetuses legal personhood. The other thing the court stressed in its decision was that protections of prenatal life should be carried out through the pregnant person and not at her expense. Notably, the court's interpretation of the American Convention's right to life in this case has been cited by high courts throughout the region, throughout Latin America, and relied upon in various landmark cases decriminalizing abortion, whether broadly or under certain circumstances. Next slide, please. So moving on to the abortion context, most, if not all, high courts that have considered a case involving the decriminalization of abortion care have had to reckon with the constitutional value and protection afforded prenatal life. And Mexico's experience is particularly relevant for the United States, given that both countries have federalist legal systems where states retain a significant amount of authority when it comes to the regulation of abortion care. In Mexico, the federal Supreme Court has been debating the constitutional value and protection afforded prenatal life in the context of abortion decriminalization cases for over 20 years. As early as 2002, prenatal personhood advocates have been arguing before the Supreme Court that the decriminalization of abortion violates fetuses' rights to life and equality under the Constitution. Now, even as the court upheld the decriminalization of abortion to be constitutional in various cases in the early 2000s, it simultaneously upheld fetuses' constitutional rights. Then slowly, over a course of more or less 20 years, the court changed its approach to constitutional protections for prenatal life. In 2011, it threw out arguments that unborn life should be treated equally to born persons. But it wasn't until 2021 that the court definitively rejected the idea that prenatal life has any fundamental rights. The 2021 case involved the constitutionality of what are called state right to life from conception provisions. And before I get to the ruling, let me just provide a bit of context about the case itself. So in response to one Mexican state's decriminalization of abortion care through the 12th week of pregnancy back in 2007, 21 of the country's 32 states amended their constitutions to protect the right to life from conception. The Supreme Court considered the constitutionality of one of these provisions alongside its consideration of other efforts at the state level to decriminalize abortion broadly. Ultimately, the court issued its rulings in both cases on the same day and upheld the constitutionality of broad abortion decriminalization and struck down state right to life from conception provisions as unconstitutional. It held that there is no constitutional obligation to protect life from conception for a couple of reasons. First, it is impossible for courts and legislatures to determine when life begins according to the law, when there is no consensus about when it begins according to science, religion, and morality. And second, while states can expand the regulation of fundamental rights, they cannot take actions that affect the core content or otherwise interfere with the exercise of other fundamental rights. In its ruling, the court also pointed to the fact that there is no international obligation to protect life from conception, stressing that international human rights law neither recognizes an absolute right to life nor defines when life begins. And so the text you'll see here on this slide shows that according to the court, prenatal personhood alters the cultural and social meaning of rights and contributes to building a social imaginary that is adverse to the exercise of pregnant people's rights. It increases stigma for those who seek these healthcare services. It generates a false fear in health personnel and causes inequality in the provision of health services among pregnant people, among other constitutionally unacceptable consequences. Next slide, please. So turning lastly to emergency contraception. Emergency contraception has also come under attack in various countries around the world, but particularly in Latin America. In the early 2000s, several countries in the region banned emergency contraception, relying on one of two primary legal arguments. The first argument is that the right to life begins at fertilization, that emergency contraception interferes with the fertilized egg's implantation in the uterus, thereby causing an abortion and violating the embryo's right to life. High courts in countries like Argentina and Ecuador use this line of reasoning to ban emergency contraception in their respective countries. The second argument, which isn't all that different, but it gets at the idea that the scientific evidence that shows that emergency contraception does not prevent implantation is not conclusive. And given the reasonable doubts associated with that evidence, the emergency contraception should be banned. And high courts in Chile and Peru relied on this line of reasoning. And if we take Chile's experience as an example, emergency contraception was first approved for distribution in 2001. And then in 2007, then President Michelle Bachelet enacted regulations that permitted emergency contraception to be distributed through the country's public health system. In response, a group of conservative lawmakers challenged those regulations as unconstitutional in 2008, and the Constitutional Court in the country ruled that the regulations were unconstitutional because they violated the Constitution's right to life as it applied to embryos. The decision has been characterized as one of the Constitutional Court's most controversial, with no other decisions stirring as much public discord and opposition in response. Not long after, President Bachelet spearheaded the drafting and submission of a bill to Congress that would roll back the emergency contraception ban. That law was passed in 2010, and that same Constitutional Court upheld its constitutionality. Most other countries in the region similarly rolled back their bans on emergency contraception around the same time. Decision makers in these countries were able to do so by relying on scientific evidence that shows that emergency contraception only has contraceptive effects and does not, in fact, cause an abortion. In other words, they directly contradicted the false characterization by prenatal personhood advocates that emergency contraception causes abortions. Moreover, after many countries in Latin America rolled back their emergency contraception bans, many governments in the region took action to make it easier to access, either by making it available without a prescription or at no cost to the user. So I now want to turn to some reflections for the US context based on our international and comparative law research on this topic. There is a lot here in the US we can take away from these experiences, whether looking to the arguments or strategies of decision makers and advocates in other countries who have successfully pushed back against prenatal personhood. So turning first to what we can learn from the arguments. Our research and analysis has shown that the legal arguments that advocates and decision makers typically rely upon to counter prenatal personhood across geographic contexts are strikingly similar. I'll quickly reference the most common ones that we came across, but also happy to go into them further during the Q&A if there's interest. So first, prenatal personhood seeks to control the bodily autonomy of women and people who can become pregnant. It assumes that the embryo or fetus's rights take precedence over the pregnant person's rights, which can result in situations where the pregnant person's life, health, well-being, dignity, and autonomy are directly threatened. Importantly, even where decision makers have granted some level of constitutional protection, not rights, but protection to prenatal life, nearly all are clear that a pregnant person's rights carry greater weight. Second, prenatal personhood imposes one religious or moral view of when life begins on an entire society. It is well established that there's no consensus, whether from a scientific or religious or moral perspective, about when life begins. This, moreover, is this entirely separate question of when a person gains legal rights, as Wendy alluded to as well. Courts in many countries have, as a result, stressed that it is neither feasible nor appropriate for judges to weigh in on this question of when life begins. Third, prenatal personhood undermines the rule of law in general. Taking prenatal personhood to its logical conclusion has some rather impractical and absurd consequences. How is an embryo or fetus expected to exercise the many rights it would be afforded were it to gain full personhood? Not surprisingly, decision makers around the world have expressed concerns about how prenatal personhood could end up distorting an entire legal system. Notably, all of these arguments are relevant to and can be used persuasively within the US legal system to push back against prenatal personhood. They are also arguments that can be linked to broader communications campaigns that seek to demystify the concept of prenatal personhood and unpack its sweeping consequences, whether for individuals or for society more broadly. So turning now to what we can learn from tactics and strategies. First, a successful response to prenatal personhood requires a multi-pronged approach. The prenatal personhood movement strategy is multifaceted, which can be hard to see when you look at how it operates in a single country or geographic context. The specific tactics it relies upon may vary depending on the political climate in a given moment in a given country. For example, in the US has been an outlier when it comes to the sheer number and diversity of provisions in criminal and civil codes that advance prenatal personhood. And it's more recently that efforts to extend constitutional rights to embryos and fetuses have really emerged in the US. Conversely, looking outside the US, prenatal personhood advocates in other countries have focused historically more on establishing constitutional protections for prenatal life and less on adopting comparable civil and criminal code provisions. However, multiple areas of the law are often referenced when a court establishes prenatal personhood through one or more judicial decisions. As Wendy mentioned in her presentation, the Alabama Supreme Court relied not only on the state civil code, but also its state constitution to advance prenatal personhood. And similarly, the Mexican Supreme Court pointed to various articles included in the country's civil and criminal codes in one of its early decisions, granting constitutional rights to prenatal life. Second, a successful response to prenatal personhood really requires a long-term strategy. It can take time to develop these types of legal arguments and even longer for these arguments to resonate with decision makers. In some countries like Mexico, it has taken advocates pushing back against efforts to advance prenatal personhood years, if not decades, to fully persuade decision makers of their legal arguments. A long-term strategy accounts for the fact that decision-making bodies may not be ready for certain arguments in a given moment and honors the important work of laying groundwork for and making incremental progress towards more transformative change. The US is clearly not alone in its fight against prenatal personhood. There are other experiences to look to and learn from beyond our borders. And we really hope that these experiences inspire new ways of thinking about some of the most pressing and complex challenges the country is currently facing in the area of reproductive health. We hope they inform, support, and enrich the important work being done by so many of you here in the US. Next slide, please. So before I hand things back to Kathy, so we can dive into the Q&A, I would just like to encourage those of you who are interested in learning more about this project to visit the website included here. You can access it using the QR code. You can find all the reports there, as well as an executive summary and other helpful resources. The final report, the one on prenatal personhood, is expected to be ready later this spring, so please stay tuned for that one. And please do get in touch, especially if you would like to learn more about our upcoming dissemination plans for these reports, or if you have other ideas about topics that could benefit from this type of transnational experience sharing. Thank you.
Awesome. Next slide. So I wanted you to all, I knew this next slide had everyone's contact information on it. So why don't we leave that one up for the rest of the time so folks can take down the information if needed. And remember, the slides will be made available to you, as will the video. I first want to say thank you to all of the presenters here. It's hard when you're the moderator and you're supposed to be paying attention to lots of things, but all you can do is zone in on the person who's talking because the content is so incredible and the presentation as well incredible. So thank you all. And we're going to get to the questions in the QA. We had some that were submitted in advance as well. So I'm going to start from the bottom for Wendy. So there were a couple of questions specifically addressed to Wendy, and I know Jennifer's going to jump in on one of them as well. But the first one is actually the last one that came in the queue for Wendy. Obviously praising for such a wonderful presentation. I'm interested in what you mean by fetal personhood creeping into the states. Can you give us a little bit more on that, Wendy? And then I think Jennifer wanted to jump in too. Or maybe that's the other one. Sorry, go ahead.
Oh, thank you. Thank you for the question. Thank you to all my co-panelists. I was so interested in listening to what everybody here had to say. As far as fetal personhood creeping into the states, yes, I would love to answer that. Legal fetal personhood is extreme. And because it's extreme, proponents of legal fetal personhood have learned not to directly argue for it. So for over 50 years, they've engaged in what I call fetal personhood creep, which is an incrementalist strategy designed to achieve by surreptitious, by around the corner methods, what they cannot achieve with candor. So here's how it usually works broadly. First, the proponents of legal fetal personhood lay a foundation by integrating fetal personhood language into official deliberations and by incorporating that language into anti-abortion healthcare laws. Then, state legislators pass laws that ostensibly protect the pregnant person, but in reality serve only to lay the groundwork for legal fetal personhood. I can give you an example of that is if a pregnant person is harmed or murdered, they say that there's a second victim. So instead of saying there's additional penalties, there's now a second victim. So they say they do that to protect the pregnant person, but what it really does is forward the legal fetal personhood agenda. After that, legislators generally hold certain categories of pregnant people legally liable for fetal ailments or for fetal ailments they fear that haven't actually happened. Generally, that's people with substance abuse disorders. So if people are found to have a substance abuse disorder or they say that they've used substances, then they are held liable because what legislators are doing are coming in from the edges. They're trying to normalize that. Then they usually start passing laws that equate pregnancy loss with the loss of a child. So that exploits the genuine pain that pregnancy loss causes to forward the legal fetal personhood agenda. And then there are increasingly severe laws to curtail the reproductive rights of minors. It always goes to minors next. And these laws play on parental fears in an effort to undermine advocates of reproductive justice and further normalize the language of controlling pregnant people or people of reproductive age. That's the creep. That's how it's coming in, usually those 5 steps. And then after those foundational steps are laid, the states are primed for bolder efforts that overtly establish legal fetal personhood to the detriment of both the pregnant person and really to society overall. So that's what I mean by creep, or those incrementalist strategies that never really say we're trying to establish legal fetal personhood, but that's what they're doing. And that's where they're going to.
Can I just say on an even more basic level, one of the things that we've seen when tracking this legislation is how it will show up in one state, and then those anti-legislators will shop it around and have conversations. So what we have seen in South Carolina then trickled over to Georgia, that trickled over to North Carolina. So we actually see very similar language popping up across the states. And so just because it started in Louisiana, we then see it then happen in Texas, and then we see it happen in Oklahoma. And so we can just really see the trickle effects across the country of this language that Wendy is talking about.
I will say, if I could just comment too, I do work some in this space myself from a policy perspective, that I think, Wendy and Jennifer saying it's stealth-like. We don't necessarily know from the language of the bill itself. And so it's really any legislation, if you're in a state, if you're in a particular country, looking at to make sure, are there any implications? And recently I was asked to take a look at a bill in Maryland where I am related to a tax deduction for families who experience pregnancy loss, whereas they would have potentially had a tax deduction had they had a child. And, my eagle eyes went up on that. Is there any concern with this legislation that we're embedding the notion of fetal personhood? And I think the answer to me was no in that particular bill. I also knew the legislator's intent was not that, but I really think we just have to look very carefully at issues like the issuance of a certificate of birth resulting in stillbirth or the like, that's fortunately being offered around the country to families who are experiencing pregnancy loss. But we just have to look at all of those bills very closely and make sure the language is carefully crafted to avoid it being used to promote that the law has established fetal personhood through the back door. Did anyone else want to comment on that question? And I think, I don't know, Wendy and Jennifer, did you answer this one about proactively preventing it from being established? I think was the similar question. Yeah. Jennifer?
Oh, Wendy, did you want to jump in first? That's fine.
There's lots of ways to approach how to be proactive. And I guess some of the most obvious are, do you approach it by saying, what's the definition of a human being? Sort of like the Universal Declaration of Human Rights is done, and say it's from birth. Or do you do it from the rights of the pregnant person and say that they get to establish it? So there's lots of ways to proactively challenge this. And I think that it's really important that people do this because we have ceded ground in this way that I don't think we should, which is when I'd like to pass it to Jennifer, who has much better on the ground ideas of how to actually move this forward.
Yeah, so Dawn, thanks so much for asking this question. We actually have a couple of examples from states who have done this, or at least have language they've introduced on this. And so happy to provide some, overview of that, where, Colorado has done some of that to reject this idea that a fertilized egg, embryo, or fetus has independent rights under state law. And so we actually have, I don't have time to go into all of the states, but I do have some really great examples from states that have proactively wanted to counter this this information or this counter fetal personhood. The other thing that I want to add for any state legislators that are on this, you have a legislator-specific webinar on fetal personhood March 6th that will be coming up, and we have concrete strategies for legislators to do just this proactive kind of eye in their state. There are a lot of states that have moved on abortion broadly policies, but to Wendy's point, have offered loopholes or ways that folks that could be interpreted as fetal personhood. And so we want to make sure that we are offering the state legislators to get proactive. And so I'm happy to share out the resource. We will have Maryland Delegate Leslie Lopez who talk to other state legislators about what they are doing. And so happy to share some information there. Rebecca?
Yeah, I just wanted to flag, I think once the report comes out, we'll have some more insights on what, from a global perspective, can be done proactively, but I'll just flag one. So there are certain property rights that are afforded to prenatal life. So there are areas of civil law where we have said that the unborn has a right to certain things. But what often happens in those provisions, in civil codes, for example, is there's a very clear caveat there saying contingent upon birth. So adding those types of caveats to the places of the law where we do afford a certain amount of protection or certain rights to the unborn can be a way to prevent courts from then relying on those provisions to more broadly interpret personhood for prenatal life.
Thank you. I'm going to jump to a question that actually relates to the first issues associated with youth. And because I don't know much about laws in Latin America, I'm really going to lean in, to Donna on this. But in the United States, we have this conundrum of wanting to respect decision-making autonomy and reproductive health space for minors. I loved the supported decision-making, concept there instead of just the autonomy, the supported autonomy. But at the same time, we're working in the criminal justice space to eliminate, reduce, more deeply regulate the use of adult charging minors as adults, incarcerating minors in adult facilities, on the kind of, I think, evidence supported basis that children don't have the same culpability in the criminal context or shouldn't as adults. Can you address any of, is that a conflict that exists elsewhere? Is that a conflict that you've had to face and tease out?
Thank you for that question. I think that it's one of the, like within the Latin American movement, we discuss this, especially in the context in which a lot of Latin American countries, particularly Argentina, for example, is now debating if they can lower the age of penal responsibility. This is a key question. But what I will say is, frankly, that these are two separate sectors, right? One is the healthcare system, and the other one is the judicial or criminal system. In the healthcare system, what we are trying to assess is if the person can understand the procedure they are going through, the consequences and the risk. And that is something that all, like as I showed in my presentation, all the evidence coming from the medical and ethical research shows that that's a thing, right? Like adolescents older than 16 can understand having an abortion or taking decisions about the pregnancy just as adults, and with younger adolescents, what they need is support or more information, but their capacity does not depend only on age alone. So that's one thing. On the criminal system, we're not thinking proactively in terms of if there's any specific procedure they are trying to understand. It's more like the question of if they can be held responsible, liable because of a past event, right? And the evidence shows, like as you said, the evidence shows that there are differences between adults and adolescents or young people in terms of that particular decision. So I think that like the common aspect of both discussions is how the evidence shows, how the evidence assess that capacity. And I think that the answers evidence provide us is different, right? Like on the one hand, in the healthcare system, the health systems, adolescents can consent because they have the ability to understand the procedure. They will consent or not. But on the other hand, in the criminal system, the evidence shows that there are differences. And the concept of evolving capacities, it's flexible enough to address that, because it's the idea that adolescents gain more autonomy as soon as or when they mature, right? So at that maturance, it's not an age-based, it's not based on an age alone, but rather on different factors. So yeah.
Thank you. That was
And Kathy, can I just add
Rebecca.
one thing quickly? There is some interesting research on the nature of decision making and how it affects an adolescent's ability to make those decisions. And one differentiation that has been looked at is the difference between hot and cold decision making among neuroscientists. And so healthcare decisions are typically referred to as cold decision making. They're not made in an instant. They're made with plenty of time, with plenty of information, and that may be another way to differentiate the types of decisions that are taking place in these two different contexts. So.
Wonderful. Thank you. Thank you. I'm going to jump back into the Q&A box and go to a question for Wendy. When you were talking, you mentioned that fetal personhood in the U.S. is already impacting medical decision making. Can you give real world examples of where this has happened?
I would be happy to. I do not know of one source that collects them all, so I go around and try and collect them all. But I can tell you that it's happened in many different ways. We have people who were denied medication because the person seeking the medication was of childbearing age. And it's not just something that has been said, that was actually recorded. The doctor's reasoning for denying that medication was actually recorded, and there's a lawsuit on it. There's multiple denials of methotrexate for arthritis, from a 14-year-old girl in Arizona to people of reproductive age across the country. In fact, those are proliferating so badly that there has been a call for patient access stories and action alerts on people who can't get that drug for their arthritis. There's been denials of medications to treat ulcers. There has been instances of people refusing blood transfusions. Of course, for C-sections have always been a problem. They're an increased problem in some states. And there's also potential impacts on what the effects on a developing pregnancy would be of x-rays, anesthesia, and drug treatment, especially for different types of cancer. So yes, there are many real world unfortunate examples of this happening in the United States already.
I would just also add on, and I'm blanking on what state it was, where a patient who would have under all other circumstances been removed from life support was maintained on life support.
Georgia.
Georgia.
That was in Georgia. And it's not the first time that's happened, right? There's also a very well-known case in Texas where the same thing, and it's actually happened more than one would think, unfortunately. Yes.
It's incredibly disconcerting. Yes. Rebecca, I'm going to jump to you both on the question here, but also we had a question asked in advance through the registration process about did the strategies that we're talking about here only work for protection of reproductive health care or abortion access, but are they also helpful to prevent the punishment of people who use drugs and are pregnant?
So I think that there has been some really interesting work done by organizations like Pregnancy Justice and others here in the US to highlight the links between the establishment of fetal personhood in particular and cases involving pregnant people who may use drugs prior to being pregnant or during their pregnancy, and how, for example, in Oklahoma, one of the seminal cases establishing a certain amount of rights and protections for prenatal life comes out of a case involving drug use during pregnancy. So these issues are connected, and I would point folks to Pregnancy Justice to learn more about the role that substance use has played in the advancement of prenatal personhood in the US in particular. We don't see the same dynamic playing out in other countries, to be honest, which is interesting. But I will say that thinking about criminalization of drug use, of substance use disorder, is something that also relates to a different report that we didn't have time to speak to today, which is Critiques of Criminal Law. And while that report is focused largely on abortion care, much of the international human rights standards and even comparative law standards around the use of criminal law in the health context can be directly applied to folks who have substance use disorder, and how we address that as a public health issue and rather than a criminal law issue. So there's some interesting arguments coming out of international experts and courts from other countries that could be applied to these issues more broadly and these populations more broadly. And it's something actually at O'Neill where we've done transnational experience sharing around other topics beyond reproductive health. We have a addiction and public policy center that has brought in, Portugal's perspective when it comes to drug policy. So this is the type of approach that can be applied really broadly to a range of issues.
Awesome, thank you. And then the other question that disappeared from the chat, because I think Donna answered it, but then said I wanted to make sure Rebecca got an answer, was about your comment about lack of consensus from the religious perspective in this space. Can you comment on that a little further?
Yes, well, Donna chimed right in, which is great. I think there's a lot of variation even within different strands of Christianity. I think the idea that life begins from conception, to my knowledge, it, comes from Catholicism, and was honestly a relatively recent doctrine that was established within the religion. So there's a lot of variation within religious traditions. Judaism, it's, when a child is born. So it's one of these really interesting sort of theoretical questions that I think we need to do a better job of linking to the law. And Wendy and I know at least one scholar who's thinking about putting together a timeline that marks all the different places in embryonic and fetal development where different disciplines ascribe some level of importance, and understanding where those things come from. Maybe it's religion, maybe it's philosophy, ethics, maybe it's science, medicine, but really putting that all together so that we can see where these different narratives that pop up in legislative debates are coming from. So,
great, thank you. There's one last question in the box. I do want to say I answered the one about whether you'll get links to the reports. They were in the chat, but we're also going to send it out in the post-webinar email that everyone will get. So I just want to mention a question that did come in before the webinar that I will actually directly answer to the person who sent it, but it had to do with the implications of the Indian Child Welfare Act and the issues that we're talking about today. And I think we all acknowledge that we are not experts in that space, but I did find two scholarly works that I think are incredibly helpful in working through that I will also include in the post-webinar email and directly to the person who asked. So I'm going to throw out this last question. I kind of saved it for the end because it is maybe the most broad, but how does legal fetal personhood interact with paternalism? It seems that they should conflict with each other, but both ideas are used to restrict abortion. Whoever wants to have it, that we've got 7 minutes.
I will jump in because I think it's really interesting. And I think it depends on your definition of paternalism. For me, paternalism is the idea that you're limiting someone else's freedom for their own good because you know better, in which case it applies to both abortion, healthcare, and fetal personhood. But because what we're telling the pregnant person in legal fetal personhood is they can't know best for their body, their pregnancy, or how it goes. So I think there's a strain of paternalism through it. I will just add before I pass it to my colleagues that there is a strain of hypocrisy through all of this. So for example, we say like for young people that it's up to their parents or society, except when extremist legislatures in the states don't agree with what the parents say. So that's why you see in certain states, they're denying hormonal treatment for gender affirming care for minors, even when the parents agree, but they're saying that the young people can no longer get abortion health care until the parents agree. So there is a lot of hypocrisy built in to what we're fighting here, which presents its own challenges. But I'd love to hear others' responses to the paternalism question.
I'm a law professor. I will call on you. Jennifer, thoughts?
No, I actually was wanting to hear from Dana because I knew she brought that up. So I was trying to see if she was going to chime in there.
All right, Jana, it's you.
No, I'm fine. Go, you.
Yeah, I think Wendy kind of summed it up for all of us. So we didn't really have much to add to that.
Fair enough. Anything else for the good of the order from our panelists?
No, the only thing that I would just add is that we have a series of reports coming out. These reports are that are out. These reports were designed specifically for state legislators to really take and look. One of the things that we point to or we name in these when we talk about these reports are how in other countries legislators or congressional members will actually cite studies from other countries, and that is kind of rare to see in the U.S. on the floor of legislators doing that. And so we're really hoping that we can see, legislators relying outside of the U.S. for strategy. And I think when we're able to do that, we can put bolder, more comprehensive healthcare policies for folks in this country. And so we really encourage folks to take a look at these reports. We will share them. We obviously dropped the link, but really would dive into, love to talk further about all of the themes across the reports. And if there is an issue or an area that you would love to have covered, please reach out and we can take a look at maybe covering that issue as well.
Thank you, Jennifer. Thank you, Wendy. Thank you, Donna. Thank you, Rebecca. And thank you to all of and to Kayleen for kicking us off and organizing us, and to all of the attendees, your terrific questions. And I know that you're going to take this information and do good with it. So I appreciate that you cared enough to come and join us today. So take care, everyone, and have a great weekend ahead.